Right. Welcome everyone to our Wednesday webinar. Berkeley Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. My name is Daniel Sturman and I'm a commercial real estate associate solicitor here at Berkeley Long. I'm based at our Chelmsford office. Thanks so much for joining me for my webinar. I hope you find it enjoyable. In the background, my colleague Katie Lockwood, who is also a commercial real estate solicitor, is on hand to assist with any questions and queries at the end of the webinar. This week, we're looking at the impact of COVID-19 on the commercial landlord and tenant relationship. We will take questions at the end, so please do make use of the Q&A facility. I'll run over the webinar, and if you would then like to ask any questions, please then type them in the chat bar below, and I will try and answer them the best that I can. It is important to note that the content of this webinar is in respect of commercial tenancies only. I'm not covering residential tenancies. My webinar will be structured in the following way. Slide, please. So the agenda. First, I will cover a general note about COVID-19 and its impact. I will mention what the government is doing to help. I will cover off some answers to common questions asked by landlords and also those from tenants' perspective, as well as some exit strategies. I will then set out what the government's code proposes to assist with and finish up with a conclusion. There will then be time to ask some questions. Slide, please. So, on the 11th of March 2020, the World Health Organization announced that the world was experiencing a major pandemic, with COVID-19 rapidly spreading across the globe. In 2021, the world is still struggling with this virus, but the game changer has arrived with vaccines that should hopefully tip the scales in our favour. The virus, however, is here to stay, and the government has stated in previous press conferences that it will never be fully eradicated. COVID has changed the world and the way we work for good. Businesses and their employees were forced into working from home to protect their safety, and many offices, workplaces were shut. Many businesses, however, adapted quickly, taking advantage of the situation, finding that office work could be carried out effectively from home, and with that, many premises were shut for good. The physical work premises represents a major overhead for businesses, and to take this overhead out of the equation is a huge cost saving. COVID represents a major challenge for both landlords and tenants, certainly for those tenants working in the hospitality, leisure and retail industry sectors. Slide, please. So, what does this mean for commercial landlords and tenants? It's not great news for owners of office space, as 21st century digital technology means that office workers can effectively work from home instead. But that does not mean that office space is redundant. The issue with working from home is that many employees experience more stress, pressure and mental health issues caused by the isolated way of working. That means that quite possibly there will always be the need for physical office environments for meetings, to socialise, and indeed much work can only be effectively carried out in person. Offices can be converted, as we know, to residential, so this may be the way forward for landlords of commercial office premises. There is some good news in that many businesses still need premises to manufacture, store and distribute products. So the age of commercial premises, in my mind, has not come to an end at all. Companies will continue to need space to operate from. Not everything can be done from home. COVID's adverse impact on business activities worldwide has been substantial. Those businesses that can't operate effectively do not make money and as a result struggle to pay rent, which is bad news for the commercial landlord. It is also bad news for the tenant, as they will be struggling to make money and will be obligated to pay rent to their landlords under their business tenancies. A commercial tenancy is an ongoing contractual arrangement, and generally standard commercial leases will remain in force subject to government statutory intervention. The government intervened early in the pandemic, instigating measures under the Coronavirus Act 2020 to prohibit landlords from taking forfeiture proceedings against commercial tenants for failure to pay rent, and this remains in effect until the end of June 2021. Therefore, landlords cannot take forfeiture proceedings against commercial tenants for not paying rent, but they can for other breaches of the lease covenants. From July 1st, unless the government guidance changes further, landlords will be able to forfeit the lease and recover the property from this point for non-payment of rent. In addition to the moratorium on forfeiture, there were changes made to the commercial rent arrears recovery, statutory demands and winding up petitions to allow businesses some breathing space to work with their landlords, but these measures will not last forever, but the government continue to monitor the situation. In my experience prior to the pandemic, I've not seen any commercial leases with rent suspension clauses that would be triggered by pandemic. Usually rent suspension is triggered by damage or destruction of the property by an insured risk. So tenants are left in a situation where they cannot use their premises, but are still obliged to pay rent. So COVID has had an adverse impact on the landlord and tenant relationship from both sides. Tenants can't use their premises during lockdown, so they can't do business. Profits suffer, so they cannot pay their rent. Subsequently, the knock-on effect is that landlords suffer as their tenants can't pay their rent, and due to government intervention, they're powerless and cannot take forfeiture proceedings for non-payment of rent. Next slide, please. So what can be done, and what is the government doing? Well, the government issued a voluntary code of practice for commercial property relationships during the COVID-19 pandemic. This is a set of principles and guidance for landlords and tenants, which can be downloaded from the link as per the slides. This code is voluntary though, and does not change the underlying legal relationship. Generally, the code states that as both businesses continue to feel the effect of COVID and the economy continues to try and recover from the shock of the pandemic, it is in the interest of both landlord and tenant to do everything reasonable possible to enable their businesses to continue to operate through the recovery period. The code promotes collaboration between landlord and tenant in these difficult times. The landlord and tenant are advised to work together to find temporary and, where possible, sustainable arrangements outside the existing letter of the lease to create a shared recovery plan. If a tenant cannot pay their rent, then they should speak with their landlord and try and agree to pay what they can, if possible, and seek a temporary payment arrangement. Those tenants who can pay their rent should continue to do so. The code presents options for the landlord and tenant to consider when agreeing new payment arrangements. The code also recommends for businesses to look for financial support offered by the government where possible, and to engage with lenders to seek flexible financial arrangements. The code is made up of 5 main principles. Of 4 main principles. First, transparency and collaboration. It is recommended that the landlord and tenant collaborate as they have a mutual business interest in business continuity that reaches beyond the pandemic and should act as partners, not opponents. The landlord and tenant should act reasonably, swiftly, transparently, and in good faith in their dealings with each other. Number 2, they should create a unified approach. So the landlord and tenant should support each other and provide help in all aspects of their dealings. Third, government support. They should understand that government-related subsidies and reliefs have been provided to provide help for businesses to meet their commitments. And number 4, acting reasonably and responsibly. Both landlord and tenant need to operate reasonably and responsibly to recognise the impact of COVID-19, to identify the mutual solutions where they are most needed. Finally, the parties should recognise that even after adopting those principles, they may not be able to reach a mutually acceptable agreement. If that is the case, then they could look to employ a third-party mediator to help facilitate negotiations if the costs were proportionate, and with the understanding that both sides would bear their own costs. The code seeks to encourage the parties to be flexible and to keep ongoing communication, seek resolution where possible without legal action. The code does still ensure that the tenant remains liable for all outgoings and rental payments, but advises landlords to support their tenants where possible until their tenants are back on their feet. The code then goes on to suggest proposed arrangements that can be agreed between the landlord and tenant to help. I will later on in this webinar explain those arrangements, but first let's answer some common questions from both landlords and tenants' perspectives and provide a little insight. Next slide, please. So, questions from the landlord's perspective. My tenant is not paying their rent. What can I do about this? From the 26th of March 2020, a commercial landlord's ability to forfeit a commercial lease due to non-payment of rent by their tenant was suspended by the government under the Coronavirus Act 2020. A commercial landlord therefore cannot take forfeiture proceedings to evict the tenant in the usual way due to non-payment of rent. This suspension lasts to the end of June 2021, so from the 1st of July 2021, unless the government intervenes further, you as the landlord can take forfeiture proceedings against the tenant and recover the property for non-payment of rent. Before doing this, however, the landlord should consider very carefully if this is the best option, as if they do take forfeiture proceedings and successfully evict the tenant, it may well be difficult to relet the property, and as a result, the landlord will be hit with empty business rates. Forfeiture is also not the only remedy available. The landlord could issue court proceedings for breach of other lease terms to recover their losses or make the tenant insolvent. For rental payments, the landlord can usually utilise CRA, Commercial Rent Arrears Recovery. This is a statutory procedure which allows landlords of commercial premises to recover rent arrears by taking control of the tenant's goods and selling them. In order to use CRA, a landlord must provide 7 days notice of enforcement. Once this period has expired, certified enforcement agents, as opposed to other types of bailiffs, may enter the property through an open or unlocked door to seize goods. At that moment, however, the government has limited the use of CRA. The government has also issued a ban on issuing statutory demands now, which are a way of enforcing payment of debt owed by way of threatening to issue proceedings for bankruptcy. Landlords are currently banned from issuing statutory demands to wind up a company where the company was unable to pay debts due between 1st of March 2020 to 12th of March 2021 due to the impact of COVID. The next question. My tenant is a large company and I know they can pay the rent. Can I force them to pay it? The answer is unfortunately no. The government has put in place a moratorium on forfeiture and other arrears recovery methods. These methods are not means tested, so no matter how large the tenant company is, you as a landlord cannot take legal action, to force the tenant to pay the rent. If the tenant refuses to pay the rent, then there is nothing the landlord can do until the 30th of June, which is when the moratorium ends. The landlord has to keep in mind, though, that the moratorium is not a rent-free period, so that means that unpaid rent should be paid by the tenant as soon as possible. Otherwise, you as the landlord can consider taking legal action from the 1st of July. The next question would be, my tenant has asked if I can agree to reduce the rent during periods when the tenant cannot use the premises. Should I agree this? Yes, you can, and that is good in some respects. At least you will still have some rent coming in, and if the landlord wants to agree to reduce the rent during the period, then it is advisable that the landlord and tenant sign and date a formal letter to record such a rent concession or deferment in writing to avoid the tenant later arguing that the rent has been varied for the remainder of the term. Another question from the landlord's perspective would be, my tenant is in arrears, but this is not because of COVID. Can I still evict them? The answer to this is no, you can't. As at this time, the moratorium I mentioned above covers business tenancies with exceptions from tenancies at will, license to occupy, and short-term tenancies for less than 6 months, regardless of whether the arrears are due to COVID or not. My tenant is paying the rent, but they are breaching other terms of the lease. Can I do anything about that? Yes, the government restriction only applies to rent arrears. So, if the tenant is in breach of a repairing obligation, then a landlord can still serve a Section 146 notice during the breach, requiring the breach to be rectified. And if the tenant then fails to remedy the breach, the forfeiture proceedings can be taken. You can also sue for damages to recover your losses for breach of the lease terms. One problem, however, is, with the current new legislation, is that it is unclear if the restriction on enforcement measures also extends to payment of service charge or not. Final question from the landlord's perspective is, my tenant says they will not pay their rent even when lockdown ends. Am I required to help them? Well, the answer is no. You don't have to help them. The tenant signed the lease, which is a legally binding contract, which requires them to observe and perform those covenants for the duration of the term. Covid-19 does not frustrate the lease and does not change that contract. Recovering the property may be possible after the 30th of June by taking formal forfeiture proceedings, but the landlord should also consider peaceable re-entry as an alternative to expensive court proceedings. And indeed, forfeiture proceedings will take time, as there will be a delay as the courts will have a large backlog of claims to deal with after the 30th of June. Next slide, please. So moving on to common questions asked from the tenant's perspective. First question is, my business is closed down during lockdown. Am I still contractually obliged to pay my rent to my landlord? The answer is yes. Your rent is still payable under the terms of your lease, unless you have expressly agreed otherwise with your landlord. If you are struggling to pay the rent, then you should speak with your landlord as soon as possible to discuss if the landlord is willing to offer any assistance in this difficult time. But bear in mind, the landlord is under no obligation to help you at all, as they may also be struggling with their own finances due to COVID. If you do agree anything with your landlord, such as rent deferral, then make sure it is clearly documented by way of side letter. It should say what you must pay and when. Remember, the full rent will still be owed. Any agreed deferral is not a rent-free period, and the landlord will be expecting the full balance of the rent owed to be paid in the future. So the tenant is advised to budget accordingly so that the remaining balance is paid as quickly as possible. The landlord cannot take forfeiture proceedings for non-payment of rent against you due to the moratorium that I mentioned previously, which is in place till the end of June. After that time, the landlord can take forfeiture proceedings against you and recover the property from you. Therefore, the landlord cannot evict you until July. If you breach other terms of your lease, then the landlord can still take forfeiture proceedings against you. Such breaches would be breach of repairing obligation, or perhaps you carry out alterations to the property without the landlord's consent. The next question would be, my landlord is saying that he will sue me. What can I do? Your landlord cannot at this time until after the end of June take forfeiture proceedings for non-payment of rent, but this is not the only remedy available to your landlord. Your lease is a legally binding contract, and failing to pay rent is a breach of that contract. The landlord can still sue you for losses or make you insolvent. The landlord can still use CRA to seize goods for the sum due for the debt, subject to limitations. The landlord cannot issue a statutory demand during the moratorium period. Another question would be, I will not be able to pay the rent after lockdown has ended. What can I do? Best advice here is again to approach your landlord and try and agree a payment plan. But the warning here is that any agreement is entirely at your landlord's discretion. Any agreement for deferral or reduced rent must be documented in writing clearly. Any document would be personal to you as the tenant and would not bind assignees of the lease. So moving on to exit strategies. So what exit strategies are available for the tenant? Due to the financial hardship caused by the pandemic, the tenant may not want to continue with the lease at all, even after the lockdown passes and the effects of the pandemic lessen. Ultimately, as the lease is a legally binding contract between the parties for the term, the landlord does not have to agree to anything. If the tenant really wants out, they should check their lease to see if they have the ability to break the lease by exercising a formal break right. If there is a break clause in the lease, and if the tenant wishes to go down this path, then they must proceed with caution and seek legal advice before they do this, as the break clause in any lease, in any commercial leases, are interpreted very strictly. And if the notice is not served correctly, or the conditions of that break are not complied with fully, then the break will be invalid and the tenant will lose the chance to break altogether and be committed to observe the lease covenants for the remainder of the term. Alternatively, the tenant could approach the landlord and request a formal deed of surrender, a document signed and dated by both parties to formally bring the lease to an early end. Again, this is totally up to the landlord to decide. The landlord is not obliged to enter into a deed of surrender. If the landlord does agree, then the tenant will most likely be required to pay the landlord's legal costs and possibly a financial premium for the release from the tenant's covenants. The tenant may struggle to get a deed of surrender and may not have the ability to break the lease. If that is the case, the tenant could look to assign and transfer the lease on to a third party if it is possible and if the property is still in demand. The downside of this, however, is that in any standard commercial lease, a condition of such assignment is usually that the outgoing tenant has to enter into an authorized guarantee agreement, which is effectively a guarantee from the outgoing tenant that the incoming assignee will pay the rent and observe the lease covenants. If the assignee defaults, the landlord can look back to the outgoing tenant to remedy the default, and in extreme circumstances, if the assignee becomes insolvent and disclaims the lease, then the landlord can require the outgoing tenant to enter into a new lease for a term equal to the residue of the term of the lease from the date of disclaimer. Therefore, the tenant is still on the hook until the assignee assigns the lease on. To ease the tenant's financial exposure caused by the rent, the tenant could look to sublet the premises if it is usable, but again, the tenant is still on the hook ultimately for the main rent payable to the head landlord and has not actually exited the arrangement at all. Failing all of these options, and if the landlord was willing to agree to it, the landlord and tenant could agree to a formal deed of variation that could be used to change and reduce the rental payments completely to a level the tenant can afford. The variation would amend the terms of the existing lease formally and would apply for the rest of the term of the lease. So moving on to new commercial leases and what can be done. Our firm is still dealing with a lot of commercial landlord and tenant work. Landlords are still granting leases at this time and tenants are still entering them. That being the case, if you are a tenant about to enter into a new commercial lease at this time, then it would be very wise to agree, or try and agree, at the heads of terms phase for a formal clause to be inserted in the lease, which will be triggered if a COVID lockdown was instigated by the government. If that happens, then the clause would say that the rent would be suspended for the lockdown period or for the time that the tenant is prevented from using the premises for its business purposes. I have to say, such clauses met with much resistance from the landlords I have dealt with recently. However, some landlords will agree to this clause, and again, it is purely up to the landlord to decide if they wish to grant the tenant the ability to have rent suspended during a COVID lockdown period. Another point for tenants to be aware of is in respect of licenses to alter. This point is not publicised much, but it is an important point to note if you're a tenant. COVID has brought social distancing, and for some premises to be COVID compliant, that means that alterations may have to be made to the premises by the tenant. Alterations are usually governed in the lease, and most are only permitted with formal consent of the landlord. If the tenant proceeds to carry out these alterations, but does not seek the prior formal consent of the landlord first, then the tenant will be in breach of the terms of the lease, and the landlord could then take forfeiture proceedings against the tenant, which can still be made during the moratorium, as that only applies to non-payment of rent. So, the best advice to the tenant here is that before they make any alterations to the property, in order to be COVID compliant, they're best to approach their landlord first for a formal license for alterations deed. Otherwise, they will risk breaching the terms of the lease and the landlord taking forfeiture proceedings. So moving on to the code proposed arrangements from the government to be considered by the landlord and tenant. I mentioned earlier in this webinar, the government issued a code of practice that is purely voluntary, This encompasses a set of principles for the landlord and tenant to adopt during these difficult times. In addition, the code sets out some proposed arrangements that the landlord and tenant can adopt to assist. The code says that in seeking any arrangement and any changes to rental payments, both parties should act in good faith, reasonably, and flexibly as per principles mentioned before. Tenants seeking concessions should be clear with their landlords about why this is needed. This means being prepared to be transparent and explaining their requests by providing financial information about their business to their landlord. This should be to an appropriate and relevant extent, which may differ from case to case. Landlords should provide concessions where they reasonably can, taking into account their own fiduciary duties and financial commitments. And landlords seeking to refuse such concessions should be clear with their tenants about why they're doing so. This means that providing a reasonable explanation of their decision, which clearly takes into account the information provided by the tenant. So possible arrangements that could be agreed between a landlord and tenant. In considering a tenant's request to renegotiate their rent, landlords may wish to bear in mind the impact of the following issues on the entire business of both tenant and landlord. This is not an exhaustive list, but could give an indication of the extent to which the tenant's financial position has been impacted across their entire business. 1, consider closure period impacting the tenant's business and the ability to trade via other means. 2, duration and extent of restricted trade due to social distancing requirements. 3, extra costs and obligations through protecting customers to adhere to social distancing requirements. 4, needs of other stakeholders such as banks, employees, suppliers during this period. 5, government support received and how this has been used. 6, tenant's previous track record under its lease terms and any concessions to the tenant already agreed. 7, the impact that providing support may have on the tenant's competitors and on other support already offered to tenants. And finally, 8, possible alternative considerations in a regulated sector, for example, pubs that are regulated under the Pubs Code. So moving on to rent. Agreeing and adhering to a new arrangement agreed by both parties should protect against forfeiture for non-payment of rent under the previous lease terms, to the extent that rent has been amended by the rent payment plan. After the Coronavirus Act 2020 moratorium on forfeiture is lifted and for so long as the rent payment plan applies. The option of new arrangements that could be agreed by both landlord and tenant include 1, a full or partial rent-free period for a set number of payment periods. 2, a deferral of the whole or part of the rent for 1 or more payment periods. 3, the payment of rent over shorter periods for a set time, i.e. monthly rather than quarterly, including provision for their payment in arrears. 4, rental variations to reduce ongoing payments to a current market rate and or to provide for all or part of the rent to be paid as a proportion of turnover of the site, incorporating any period during which the site was closed. 5, landlords drawing from rent deposits on the understanding that the landlord will not then require the deposit to be topped up by the tenant before it is realistic and reasonable to do so. 6, reductions in rent, either in whole or part, across other units occupied by the tenant and owned by the landlord as part of a negotiated agreement applying to a portfolio of units. 7, landlord waiving contractual default interest on unpaid rents or rents paid in arrears to make payment plans more affordable. 8, provisions for ending the solutions on a fixed date or on reaching a trigger point of particular circumstances. 9, tenants and landlords agreeing to split the costs of rent for the unoccupied period between them. And 10, finally, any of the above that I've explained in return for other arrangements, i.e. a reversionary lease on reasonable terms, the removal of a break right in favour of the tenant, or an extension of the lease. So I mentioned service charge briefly earlier. The code goes on to speak about service charges and insurance charges. The government states that it is important that buildings continue to be insured and safely maintained so that they are ready to support the economy's recovery after the pandemic. Any service charge and insurance charge payable under the lease is not profit making, and unless otherwise agreed, needs to be paid in full according to the code. Recognising the impact this may have on tenants' finances in relation to service charges, these should be reduced accordingly where the lack of use of a property has lowered the service charge costs incurred. Conversely, it is acknowledged that in some cases there may be additional service costs required, e.g. in order to operate a building which complies with health and safety requirements in the context of COVID-19 or recommissioning where buildings are reopened. Landlords should ensure that service charge costs are reduced where practical and consistent with providing best value for occupiers. Where possible, the frequency of a tenant's service charge payments should be spread over shorter periods. Where there is a known net reduction in overall service charge due to lack of use of a property, taking into account an additional COVID-19 related costs, this reduction should be passed on to tenants as soon as possible ahead of the end of year reconciliation in order to help with cash flow and business viability. Landlords should also ensure that all management fees reflect the actual work carried out in managing the services and the service charge during COVID-19 crisis. Any solution the parties reach in relation to the service charge should take into account the RICS professional statement, service charge and commercial property. So that is the government's voluntary code designed to help landlords and tenants through lockdown periods. Next slide, please. So on to a conclusion. So to conclude, I've summarised the general impact that COVID-19 has had on the commercial landlord and tenant relationship, how the government is trying to help with the publication of its voluntary code, dealt with common questions asked by the landlord and tenants, summarised the various legal options available to landlord and tenants, set out various exit strategies for the tenant and the proposed options available to the parties which are included in the government's code. Unfortunately, COVID is here to stay, for the moment at least, and will be part of working life for years to come, it would appear. Businesses will need to adapt to survive, and I'm sure we will see more clauses covering lockdown periods in new commercial leases going forward, required in order to protect tenants during lockdown periods and to prevent landlords from claiming rent from their tenants for such periods. The best way for landlords and tenants during lockdown periods would appear to be to communicate with each other and to assist and support each other as best that they can so that they can come to an arrangement in respect of their respective obligations in the lease, so that when the lockdown period lifts, the landlord still has a viable tenant. I do hope you found this webinar interesting and that it has given you an insight into the legal issues that landlords and tenants are facing during these difficult times. Before we take questions, we will be sending a recording round to everyone that signed up to today's webinar tomorrow morning. Next slide, please. We'll also include a link to a very short feedback survey, and we'd really appreciate it if you could complete that so we can make sure our future events are helpful to you. Next slide. As I said at the start, this is one in a series of Wednesday webinars. Our next webinar is an employment law update. If you are interested in future webinars, please do visit our website or Eventbrite page to sign up. Next slide, please. So now is the time to ask some questions. So if you've got any questions, please do ask and I'll try and answer them best that I can.
Hi, Dan. We have had a few questions
Okay.
in.
Yeah.
First of all, could you just clarify the best way for a commercial tenant to protect themselves before entering into a commercial lease?
Well, the best way at this time, if you're about to enter into a commercial lease, would be to try at the heads of terms stage. So that's before the lease is actually completed. Generally, there's usually agents, or if you're negotiating with a landlord, it's best to agree a set of heads of terms which covers the main points of the lease, so rent, term, whether there's a break clause. The best thing to do at that stage, the early on stage, is to try and raise at that time to see if a COVID rent suspension clause could be inserted in the lease and make it a heads of term, so that when it comes to actually the lease landing on the tenant's lawyer's desk, there is a COVID clause in there, not to leave it until after the heads of terms, because at that point it might be too late really. The landlord will say, well, I never agreed to that. It may also be advisable to see if you can agree a break right, as in a rolling one, to give very short notice to the landlord to end the lease. Like I said before, it all depends on the landlord. Some won't want to agree at all because it gives the tenant a lot of flexibility and they want their rent paid. But like I said, it very much depends on the landlord. Those kind of provisions, if you're about to enter into a commercial lease, would be sensible. If you've already entered into a commercial lease, then and you're struggling to pay the rent, well, first of all, you don't have to pay at the moment because of the moratorium, but it would be advisable to try and agree a payment plan with your landlord. So approach them and try and agree a rent payment plan, because at the end of the day, the moratorium is not there to say, it's not saying that you're not paying rent for that period. The rent's still owed, the lease is still in effect. It's not frustrating the lease, so you've really got to be trying to pay that rent if you can. So some sort of rent payment plan to be documented by way of side letter would be a good thing to have in place with your landlord if you've already actually committed to the lease and it's already been completed, and the lease was completed before the COVID pandemic.
Okay, thank you. The next one is, if you insert the new clause you mentioned into a new lease, but rather than saying rent suspension, could you say a reduced rent for the lockdown period will be considered?
You could. I mean, you can try that as well. Yeah, that can go in. Like I said, a lease is a contract, so you can cover that off in a clause in the lease. So if there was a lockdown, you could have some clauses in there to say that the rent could be reduced to a certain amount during that period. Yes, that can be done. And again, that would be quite a sensible way to deal with it. Yep.
And then I think our last one's a nice easy one for you. Can you help negotiate with a landlord?
Well, generally we can. We can do that. I would probably say it's best to get an experienced surveyor, as in a commercial landlord surveyor, or a tenant surveyor, to act on your behalf to agree some good heads of terms, and we can certainly recommend people to you to help you with that, because it's really important that the heads of terms are agreed first, and a good agent is instructed to agree those heads of terms first, because if you don't have any heads of terms and you haven't mentioned this at heads of terms stage, once the lease is drafted, you may very well struggle getting it agreed or even completed, and you could just be wasting your time. So you really need to raise these points now if you are in the situation where you're negotiating commercial lease. So get an agent, I would say, first of all, experienced surveyor. We can recommend one. Get your heads of terms, mention COVID to them. I mean, any experienced surveyor should be mentioning this to you anyway if they're acting for you as a tenant, and trying to get those clauses in if possible. But like I said, some landlords don't want it, they don't like it. It very much depends on the landlord and how reasonable they're willing to be. So yeah.
Well, thank you, everyone. That's all the questions for this evening. Okay.
Well, thank you, everybody. We'll review any questions further, and if you need to contact us, please do email you've got my contact details there, my telephone number there. Please do get in touch. Thanks very much.